Naturalization is the legal act or process by which a non-citizen in a country may acquire citizenship or nationality of the country. It may be done by a statute, without any effort on the part of the individual, or it may involve an application and approval by legal authorities. The rules of naturalization vary from country to country and typically include a minimum legal residency requirement, and may specify other requirements such as knowledge of the national dominant language or culture, a promise to obey and uphold that country's laws. An oath or pledge of allegiance is also sometimes required. Some countries also require that the person renounce any other citizenship that they currently hold, forbidding dual citizenship. But whether this renunciation actually causes loss of the person's original citizenship, as seen by the host country and by the original country, will again depend on the laws of the countries involved. The massive increase in population flux due to globalization and the sharp increase in the numbers of refugees following World War I created a large number of stateless persons, people who were not citizens of any state. In some rare cases, procedures of mass naturalization were passed, as naturalization laws had been designed to cater for the relatively few people who had voluntarily moved from one country to another. Western democracies were not ready to naturalize the massive influx of stateless people which followed massive denationalizations and the expulsion of ethnic minorities from newly created nation-states in the first part of the 20th century, but they also counted the Russians who had escaped the 1917 October Revolution and the war communism period, and then the Spanish refugees. As Hannah Arendt pointed out, internment camps became the only nation of such stateless people, since they were often considered undesirable and were stuck in an illegal situation. Since World War II, the increase in international migrations created a new category of refugees, most of them economic refugees. For economic, political, humanitarian and pragmatic reasons, many states passed laws allowing a person to acquire the citizenship after birth, in order to reduce the scope of this category. However, in some countries this system still maintains a large part of the immigrated population in an illegal status, albeit some massive regularizations. Laws by country. China. The People's Republic of China gives citizenship to persons with one or two parents with Chinese nationality who have not taken residence in other countries. The country also gives citizenship to people born on its territory to stateless people who have settled there. Furthermore, individuals may apply for nationality if they have a near relative with Chinese nationality, if they have settled in China, or if they present another legitimate reason. The naturalization process starts with a written application. Applicants must submit 3 copies, written with a ballpoint or fountain pen, to national authorities, and to provincial authorities in the Ministry of Public Security and the Public Security Bureau. Applicants must also submit original copies of a foreign passport, a residence permit, a permanent residence permit, and 4 2.5-inch long pictures, according to the conditions outlined in the Nationality Law of the People's Republic of China. Authorities may also require any other material that the authority believes are related to the nationality application. India. The Indian Citizenship and Nationality Law in the Constitution of India provides single citizenship for the entire country. The provisions relating to citizenship at the commencement of the Constitution are contained in Articles 5 to 11 in Part 2 of the Constitution of India. Relevant Indian legislation is the Citizenship Act 1955, which has been amended by the Citizenship Act 1986, the Citizenship Act 1992, the Citizenship Act 2003, and the Citizenship Ordinance 2005. The Citizenship Act 2003 received the assent of the President of India on 7 January 2004 and came into force on 3 December 2004. The Citizenship Ordinance 2005 was promulgated by the President of India and came into force on 28 June 2005. Following these reforms, Indian nationality law largely follows the jus sanguinis as opposed to the jus soli. Indonesian nationality is regulated by Law No. 12/2006. The Indonesian nationality law is based on jus sanguinis and jus soli. The Indonesian nationality law does not recognize dual citizenship except for persons under the age of 18. After reaching 18 years of age, individuals are forced to choose one citizenship. A foreign citizen can apply to become an Indonesian citizen with the following requirements: age 18 or older, or married, resided in Indonesia for a minimum of 5 consecutive years or 10 non-consecutive years. Physically and mentally healthy, ability to speak Indonesian and acknowledge Pancasila and Undang-Undang Dasar Negara Republik Indonesia Tahun 1945. Never convicted of a crime for which the punishment is imprisonment for 1 year or more. If having Indonesian citizenship will not give the person dual citizenship. Employed to have fixed income. Pay citizenship fee. Any application for citizenship is granted by the President of Indonesia. Israel's Declaration of Independence was made on 14 May 1948, the day before the British Mandate was due to expire as a result of the United Nations Partition Plan. The Israeli Parliament created 2 laws regarding immigration, citizenship and naturalization: the Law of Return and the Israeli Nationality Law. The Law of Return, enacted on July 15, 1950, gives Jews living anywhere in the world the right to immigrate to Israel. This right to immigrate did not and still does not grant citizenship. In fact, for 4 years after Israel gained independence, there were no Israeli citizens. On July 14, 1952, the Israeli Parliament enacted the Israeli Nationality Law. The Nationality Law naturalized all citizens of mandated Palestine, the inhabitants of Israel, on July 15, 1952, and those who had legally resided in Israel between May 14, 1948, and July 14, 1952. The law further clarified that naturalization was available to immigrants who had arrived before Israel's creation, immigrants who arrived after statehood was granted, and those who did not come to Israel as immigrants but have since expressed desire to settle in Israel, with restriction. Naturalization applicants must also meet the following requirements: be over 18 years of age, have resided in Israel for 3 out of the 5 preceding years, have settled or intend to settle permanently in Israel, have some knowledge of Hebrew, and have renounced prior nationality or demonstrated ability to renounce nationality after becoming a citizen of Israel. Because of Israel's relatively new and culturally mixed identity, Israel does not grant citizenship to persons born on Israeli soil. Instead, the government chose to enact a jus sanguinis system, with the naturalization restrictions listed above. There is currently no legislation on second-generation immigrants. Furthermore, foreign spouses can apply for citizenship through the Minister of the Interior, but have a variety of restrictions and are not guaranteed citizenship. Russia. Naturalization in Russia is guided by Articles 13 and 14 of the Federal Law about Citizenship of Russian Federation, passed on May 31, 2002. Citizenship of Russia can be obtained in general or simplified order. to become a citizen in general order, one must be 18 years of age or older, continuously live in Russia as a permanent resident for at least 5 years, have legal means of existence, promise to obey the laws and constitution of Russia and be fluent in Russian language. There is also a possibility to naturalize in a simplified order, in which certain requirements will be waived. Eligible for that are persons, at least one parent of whom is a Russian citizen living on Russian territory, persons who lived on the territories of the former Soviet republics but never obtained citizenships of those nations after they gained independence, persons who were born on the territory of RSFSR and formerly held Soviet citizenship, persons married to Russian citizens for at least 3 years, persons who served in Russian armed forces under contract for at least 3 years, parents of mentally incapacitated children over 18 who are Russian citizens, participants of the state program for assisting compatriots residing abroad, and some other categories. South Africa. Chapter 2 of the South African Citizenship Act, enacted on October 6, 1995, defines who is considered a naturalized citizen at the time of the Act and also outlines the naturalization process for future immigrants. Any person who immediately prior to the commencement of the Act had been a South African citizen via naturalization, had been deemed to be a South African citizen by registration, or had been a citizen via naturalization of any of the former states now composing South Africa, is now considered to be a naturalized citizen of South Africa. Those wishing to apply for naturalization in the future must apply to the Minister of Home Affairs and must meet a slew of requirements. First, naturalization applicants must be over the age of 18 and must have been a permanent resident of South Africa for 1 year prior to application and, for 4 out of the 8 years prior to application, applicants must also demonstrate good character and knowledge of the basic responsibilities and privileges of a South African citizen. The ability to communicate in one of the official languages of South Africa is also required. Applicants must show the intention to reside in South Africa after naturalization, and they are required to make a declaration of allegiance. According to Article 3, subsection 3 of the South African Constitution, national legislation must provide for the acquisition, loss and restoration of citizenship. Being a naturalized South African citizen is a privilege, not a right. Even after meeting all the requirements and going through the naturalization process, the minister holds the right to deny citizenship. Foreign spouses of South African citizens can apply for naturalization after 2 years of marriage, but is subject to potential denial of the minister. The minister can also grant citizenship to minors, if the parent applies for them. The minister also holds the power to revoke naturalization at any time for specific reasons listed in the Act. Reasons for revoking the naturalization certificate include marrying someone who is a citizen of another country and holding citizenship in another country, or applying for citizenship of another country without prior authorization for retention of citizenship. If a permanent resident is denied naturalization, he or she must wait at least 1 year before reapplying. United Kingdom. There has always been a distinction in the law of England and Wales between the subjects of the monarch and aliens. The monarch's subjects owed the monarch allegiance, and included those born in his or her dominions and those who later gave him or her their allegiance. Today, the requirements for naturalization as a citizen of the United Kingdom depend on whether or not one is the spouse or civil partner of a citizen. An applicant who is a spouse or civil partner of a British citizen must hold indefinite leave to remain in the UK, have lived legally in the UK for 3 years, been outside of the UK no more than 90 days during the 1-year period prior to filing the application, show sufficient knowledge of life in the UK, either by passing the Life in the United Kingdom test or by attending combined English language and citizenship classes. Proof of this must be supplied with one's application for naturalization. Those aged 65 or over may be able to claim exemption, meet specified English, Welsh or Scottish Gaelic language competence standards. Those who pass the Life in the UK test are deemed to meet English language requirements. For those not married to or in a civil partnership with a British citizen, the requirements are 5 years legal residence in the UK, indefinite leave to remain or equivalent for this purpose must have been held for 12 months. The applicant must intend to continue to live in the UK or work overseas for the UK government or a British corporation or association. The same good character standards apply as for those married to British citizens. The same language and knowledge of life in the UK standards apply as for those married to British citizens. United States. In the United States of America, the Constitution gives Congress the power to prescribe a uniform rule of naturalization, which is administered by state courts. There was some confusion about which courts could naturalize. The final ruling was that it could be done by any court of record having common law jurisdiction and a clerk and seal. The Constitution also mentions natural-born citizen. The first Naturalization Act used the phrases natural-born and native-born interchangeably. The Constitution does not mandate race-neutral naturalization. Until 1952, the Naturalization Acts allowed only white persons to become naturalized citizens. Naturalization is also mentioned in the 14th Amendment. The Supreme Court, in the case of Minor v. Happersett, explained who the citizens of the United States were before its adoption. The court said, before the 14th Amendment, the Constitution of the United States did not in terms prescribe who should be citizens or of the several states, yet there were necessarily such citizens without such provision. Additions might always be made to the citizenship of the United States in two ways: first, by birth, and second, by naturalization. Before the U.S. Constitution was adopted, individual states set their own standards for citizenship. After adoption, all state citizens became ipso facto a citizen of the United States, and all children born in the United States, of parents who were its citizens, became themselves, upon their birth, citizens. These were natives and natural-born citizens, as distinguished from aliens or foreigners. The 14th Amendment states that all persons born and naturalized in the United States and subject to the jurisdiction thereof shall be citizens of the United States and of the state in which they reside. The Minor v. Happersett Court went on to say, some authorities go further and include as citizens children born within the jurisdiction without reference to the citizenship of the parents. As to this class there have been doubts, but never as to the first. The Supreme Court later, in the case of Afro-Yim v. Rusk, interpreted this clause to imply that a naturalized citizen cannot be subsequently deprived of U.S. citizenship involuntarily. The Naturalization Act of 1795 set the initial rules on naturalization. Free, white persons who had been resident for 5 years or more. The Naturalization Act of 1798, part of the Alien and Sedition Acts, was passed by the Federalists and extended the residency requirement from 5 to 14 years. It specifically targeted Irish and French immigrants who were involved in Democratic-Republican Party politics. It was repealed in 1802. An 1862 law allowed honorably discharged Army veterans of any war to petition for naturalization, without having filed a declaration of intent, after only 1 year of residence in the United States. An 1894 law extended the same privilege to honorably discharged 5-year veterans of the Navy and Marine Corps. Over 192,000 aliens were naturalized between May 9, 1918 and June 30, 1919, under an Act of May 9, 1918. Laws enacted in 1919, 1926, 1940, and 1952 continued preferential treatment provisions for veterans. Passage of the 14th Amendment meant that, in theory, all persons born in the United States, and subject to the jurisdiction thereof, are citizens regardless of race. Citizenship by birth in the United States, however, was not initially granted to Asians until 1898, when the Supreme Court, in the case of United States v. Wonkimark, held that the 14th Amendment did apply to Asians born in the United States to alien parents who have a permanent domicile and residence in the United States. The enabling legislation for the naturalization aspects of the 14th Amendment was the Naturalization Act of 1870, which allowed naturalization of aliens of African nativity and to persons of African descent, but is silent about other races. The 1882 Chinese Exclusion Act banned Chinese workers and specifically barred them from naturalization. The Immigration Act of 1917 extended those restrictions to almost all Asians. The 1922 Cable Act specified that women marrying aliens ineligible for naturalization lose the U.S. citizenship. At the time, all Asians were ineligible for naturalization. The Immigration Act of 1924 barred entry of all those ineligible for naturalization, which again meant non-Filipino Asians. Following the Spanish-American War in 1898, Philippine residents were classified as U.S. nationals, and the 1917 Jones-Shafroth Act granted U.S. citizenship to citizens of Puerto Rico, but the 1934 Tidings-McDuffie Act reclassified Filipinos as aliens and set a quota of 50 immigrants per year, and otherwise applying the Immigration Act of 1924 to them. The quotas did not apply to Filipinos who served in the United States Navy, which actively recruited in the Philippines at the time. Asians were first permitted naturalization by the 1943 Magnuson Act, which repealed the Chinese Exclusion Act. India and the Philippines were allowed 100 annual immigrants under the 1946 Filipino Naturalization Act. The War Brides Act of 1945 permitted soldiers to bring back their foreign wives and established precedent in naturalization through marriage. The 1952 Immigration and Nationality Act lifted racial restrictions, but kept the quotas in place. The Immigration Act of 1965 finally allowed Asians and all persons from all nations be given equal access to immigration and naturalization. Illegal immigration became a major issue in the United States at the end of the 20th century. The Immigration Reform and Control Act of 1986, while tightening border controls, also provided the opportunity of naturalization for illegal aliens who had been in the country for at least 4 years. Today, lawful permanent resident aliens can apply for naturalization in the United States after 5 years, unless they continue to be married to a U.S. citizen, in which case they can apply after 3 years of permanent residency. The Child Citizenship Act of 2000 streamlined the naturalization process for children adopted internationally. A child under age 18 who was adopted by at least one U.S. citizen parent, and is in the custody of the citizen parent, is now automatically naturalized once admitted to the United States as an immigrant or when legally adopted in the United States, depending on the visa under which the child was admitted to the United States. Other countries. The following list is a brief summary of the duration of legal residence before a national of a foreign state, without any cultural, historical, or marriage ties or connections to the state in question, can request citizenship under that state's naturalization laws. Mass naturalizations. A few rare mass naturalization processes have been implemented by nation-states. In 1891, Brazil granted naturalization to all aliens living in the country. In 1922, Greece massively naturalized all the Greek refugees coming back from Turkey. The second massive naturalization process was in favor of Armenian refugees coming from Turkey, who went to Syria, Lebanon or other former Ottoman countries. Reciprocally, Turkey massively naturalized the refugees of Turkish descent or other ethnic backgrounds in Muslim creed from these countries during a redemption process. Canada instituted a mass naturalization by Act of Parliament with the enactment of the Canadian Citizenship Act 1946, after annexation of the territories east of the Curzon Line by the Soviet Union in 1945. Soviets naturalized en masse all the inhabitants of those territories, including ethnic Poles, as well as its other citizens who had been deported into the Soviet Union, mainly to Kazakhstan. Those persons were forcibly naturalized as Soviet citizens. Later on, Germany granted to the ethnic German population in Russia and Kazakhstan full citizenship rights. Poland has a limited repatriation program in place. The most recent massive naturalization case resulted from the Argentine economic crisis in the beginning of the 21st century. Existing a slightly updated right of return laws in Spain and Italy allowed many of the diasporic descendants to obtain, in many cases to regain, naturalization in virtue of jus sanguinis, as in the Greek case. Hence, many Argentine and Latin Americans acquired European nationality. Since the 14th Amendment to the United States Constitution grants citizenship only to those born and naturalized in the United States, and subject to the jurisdiction thereof, and the original United States Constitution only grants Congress the power of naturalization. It could be argued that all acts of Congress that expand the right of citizenship are cases of mass naturalization. This includes the acts that extended U.S. citizenship to citizens of Puerto Rico, the United States Virgin Islands, Guam, and the Northern Mariana Islands, as well as the Indian Citizenship Act of 1924, which made all Native Americans citizens. In occupied territories, the mass naturalization of native persons in occupied territories is illegal under the laws of war. However, there have been many instances of such illegal mass naturalizations in the 20th century.